big news coming out of the Supreme Court, but there's, for us, bigger news coming out of Wisconsin courts, and Rick Esenberg joins me to talk about that with regard to our congressional maps. Two challenges to the existing congressional maps both go down in flames. This is unabashedly excellent news, and Wisconsin Institute for Law and Liberty was largely a part of the success of these cases. Thanks for joining me.
Thanks for having me, Vicki.
So there were two cases. What were the difference between these two cases?
Not a lot. I mean, one of them made a partisan gerrymandering claim that was called a partisan gerrymandering claim. The other tried to dress it up as an anti-competitive gerrymandering claim. That is, they weren't saying that the Republicans drew, or that the maps, the congressional maps, which actually, long story, were actually drawn by Tony Evers, that these maps were not drawn to advantage one party or another, but they were drawn to protect incumbents. And for some reason, that's unconstitutional under the Wisconsin Constitution. But it really turns out to be a partisan gerrymandering case because the gravamen of their complaint, the basis of their complaint, it turns out to be that the map disfavors Democrats.
And it disfavors Democrats because Democrats concentrate their population in urban areas.
That's right. I mean, the argument is typically made, well, look, this is, statewide races between Democrats and Republicans. They're usually about 50-50 in Wisconsin. They're very close. And so you shouldn't have 6 Republican congressmen and 2 Democrat congressmen. That's somehow unfair, whether you want to call it a partisan gerrymander or an anti-competitive gerrymander. The problem with that is our law provides for congressional members to be elected from geographic districts, a single member from geographic districts. And if that's the case, there's no reason to expect that the outcome of 8 different congressional races will match the statewide proportion for Democrats and Republicans, because, as you pointed out, that would only happen if Democratic and Republican voters were evenly dispersed throughout the state, and we know that they're not. Democrats are more concentrated than Republicans. Therefore, if you have a single-member geographic districts, that will tend to favor Republicans, even if nobody is even thinking about the partisan outcome at the time that they draw the maps.
We should be clear here. The exact argument they are making or attempted to make twice in 2 different ways, they're the same argument. You shouldn't be allowed to partisan gerrymander, is the argument that they were claiming they needed a partisan gerrymander in Virginia to wipe out 4 or 5, I think it was 5 Republican Congress people. So a 50-50 state, Virginia, they needed to wipe out 5 Republican Congress people and only have 1 because that's a fair map. And they're saying the exact opposite in Wisconsin. Look, they're trying to get the courts to make the political decision on what the district should look like, but they're only using certain courts, Rick. They're only going into places where they think there are liberal judges that will give them what they want. And happily, in Wisconsin, that was not the case because the courts have long held that drawing the maps is the stuff of the legislature. And if you want to change the way maps are drawn, pass a law, change the Constitution, whatever. But otherwise, the legislature can be jerks about how they drew the map, just like they are in Illinois.
Right. And, that is precisely what's happened. Federal courts are out of the business of evaluating gerrymandering. And the Wisconsin Supreme Court, said in the Johnson case after the 2020 census that they're not going to consider claims of a partisan gerrymander. That has never been overruled. And so the 3-judge panel did the right thing. They said, look, we're circuit court judges, even if we're sitting as a panel in this case because it involves redistricting. We don't have the authority to overturn binding Wisconsin Supreme Court precedent, and we're not going to do that. No matter how we might personally feel about this, it did what judges are supposed to do, and it was the right outcome in both of these cases.
All right. Doesn't mean it's not gonna. It's ended. It doesn't mean that the challenges to the maps are over. But put it this way: if the Democrats take back control of the legislature in 2020, you're not going to hear another peep about this stuff because they are going to use the political authority they have, and they're going to draw the maps however they damn well please. And then when the Republicans complain about it, they're going to say, "Oh, it's just fair maps here." And if the Republicans take them to court, they will whine and claim that the Republicans are trying to have, some judicial supremacy. This is how it goes. But again, all anyone needs to do is go look at the Illinois congressional map. Just go look at the Illinois map and you will see how, if you don't control the legislature, what ends up happening and how aggressively gerrymandered districts become solely based on the politics of the legislature.
Right. I mean, gerrymandering, if you don't like gerrymandering, you got both political parties in various places to blame for it because, it's what politicians tend to do.
You think? Yes, it is what they do.
And as long as the voters don't punish them for it, they're going to continue to do it.
So here's the thing. In Virginia, they had an independent commission. That's what they decided. Was it like 2021 or something like that? We're going to have an independent commission. If you don't notice Illinois is not offering up an independent commission. The only reason they were offering up an independent commission in Virginia is because it's a purple state. But if you don't like partisan gerrymandering, then you would advocate for an independent judicial map drawing commission, wouldn't you? And you can do that if you want. But isn't it weird that in the states where there are aggressively politically gerrymandered maps, Illinois, you don't hear anybody asking for that kind of stuff. It only seems to be when the Democrats tend to not be able to dominate in those races.
Yeah, right. Virginia had an independent commission, but they really, really wanted to gerrymander. So, they put something on the ballot, which at least they said would allow them to do it, this time. And, there are a whole bunch of legal issues surrounding that, ballot initiative. I mean, I don't know. I mean, it essentially said, look, should we allow the legislature to redraw the maps so that they'll be fair? Well, what does that mean? I mean, it is, that's a problem every time somebody says, well, we should pass a law that bans partisan gerrymandering. And my question always is, okay, but the first thing you have to do before you ban something is you have to decide what it is and give courts a way to discern what it is in any case for them. And that's very difficult to do in this
So I guess
area.
It's not gerrymandering the state legislative maps that Tony Evers insisted that we adopt so that now I, who lives in Jefferson County, am represented by someone from Madison in Dane County. So that's a fair map. Apparently, that's not gerrymandered at all. Of course, that is not how the Republicans look at it. It certainly isn't how I look at it. But those are the spoils.
Yeah, what happened in the later case, the Clark case, which resulted in the situation that you find yourself in, Vicki, is a classic gerrymander. You take a concentrated group of voters and then you spiral pizza slices, I mix my metaphors there, outward in order to capture people like you who live in Jefferson County, who live in an area which is very, very different than downtown Madison, for example. And, this is the way a classic gerrymander is done.
So I've been gerrymandered out of representation. I have no representation. I live in a rural county and I'm represented by urban interests. So that's a gerrymander, but the Democrats call that fair maps. Okay, before I run out of time, and I've only got like 2 minutes, this Supreme Court case, a lot of people thought it might be a very narrow ruling, but it looks a lot more aggressive than a very narrow ruling, which basically says you don't just get to say skin color equals representation. That's pretty big.
Yeah, it's huge. It's consistent with the way that the court has been ruling against the racialization of government decisions. It's under Section 2 of the Voting Right. It had been interpreted to really impose an affirmative obligation to draw maps in a way that would produce, representatives who are members of racial minorities, whether there had been active discrimination ongoing in that area or not in recent years. And the court put an end to that. It was expected they would do this. As I said, it's consistent with the way that they've been dealing with racial matters. They are moving towards non-discrimination and not, compensatory use of race to do a variety of things like affirmative action in this. I think it's the right decision, and I think it's something to celebrate.
I think you're right about that. I'm glad they didn't just say, okay, well, we're going to find a reason to say Louisiana's maps. We have to, that there's something wrong with them, but they made it a broad decision that affects everyone. Rick Esenberg, thank you very much. Wisconsin Institute for Law and Liberty. Excellent work as always on these cases. What would we do without you? will-law.org. Thanks so much.
Thank you.